Service of summons is a necessary step during the early phase of a lawsuit. Providing service of summons means that you let the other person involved know about the court proceeding and about your lawsuit. However, Arkansas court rules explain how you must tell or notify the other person or people involved in your lawsuit. If you have an attorney, then your attorney will take care of providing service to the other person or people in the lawsuit. If you are representing yourself, this video describes the process of providing service. Representing yourself in court without a lawyer is called pro se. You may hear this term during your lawsuit. Step 1. When and how to provide service of summons. Anytime you start a legal action and file forms with a court, the other person involved must be notified. This person is the defendant. It is your responsibility as the plaintiff to let the defendant know about the court proceeding by making sure that the defendant receives a copy of the court forms like the summons and complaint. If you do not do this, the judge may decide to dismiss your case. In legal terms, this notification is called service. For example, in a divorce, you have to let your spouse know that you have filed for a divorce. Another example is changing your child's name. You have to let the other parent know that you have filed forms with the court to change the child's name. It is very important that you understand when and how to notify the other party. It is also very important that you have proof of notification, which you have to give to the court. When to provide service. You have 120 days or about 4 months from the time you file your court forms to notify the defendant. If you do not notify the defendant within this time frame, the judge may decide to dismiss your case. How to provide service. Service can be done in a number of ways, depending on whether you do or do not know where the defendant lives or whether that person has an attorney representing them. There are a few options for how you can notify the defendant. You must use one of these options. Remember, you cannot simply tell the defendant that you have started a legal action against him or her. If you know the defendant's home address, the defendant can be notified either in person or through the mail. If you do not know the defendant's home address or whereabouts, then you may be able to use a method called service by publication. See our resources for service by publication at www.arlegalservices.org/service. If you do know the defendant's home address, then continue with this video resource to learn more. Personal service. The following 2 people are allowed to deliver the summons and complaint to the defendant at his or her home. 1. A sheriff of the county where the defendant lives, or 2. A private process server who you can hire to deliver the summons and complaint. You can find a list of people qualified to do this in the yellow pages. If the defendant is not at home, the papers may be left with a resident of the home as long as that person is at least 14 years old. The paperwork cannot be left on the doorsteps of the home. If the summons and complaint are going to be hand-delivered to the defendant, you must get a certificate of service signed by the person who delivered the summons and complaint, either the sheriff or process server. Service by mail. You can also mail the summons and complaint to the defendant's home address. You must use certified mail that has restricted delivery so that only the defendant may sign the package. It is very important that you get the signed return receipt from the mail delivery. You will attach the signed return receipt to an affidavit of service form and file it with the court clerk. If you do not provide the required proof within 30 days, the judge may decide to dismiss your case.